Hi, I'm Alyson DiLena from the law firm St. Onge, Steward, Johnston, and Reens in Stamford, Connecticut. Today I'm going to be discussing a recent Federal Circuit opinion concerning the validity of continuation patent applications. The Federal Circuit is the Court of Appeals in the United States that hears all patent matters, and the opinion is Immersion Corp versus HTC Corp, and it deals with an issue that could have affected the validity of over 10,000 U.S. continuation patent applications. The good news is that the Federal Circuit upheld the validity of all those continuation patent applications that were potentially at risk. A continuation patent application is a patent application that follows and claims priority to an earlier filed patent application, and the earlier application is often called a parent application. The continuation uses the same specification as the pending parent application, claims the priority based on the filing date of the parent, and must name at least one of the inventors named in the parent application. This type of application is useful when a patent examiner allowed some but rejected other claims in an application, or where an applicant may not have exhausted all the useful ways of claiming a different embodiment of the invention. Also, being able to continue an application and claim priority to the date of a parent will shrink the universe of prior art that is available when determining patentability of the claims in an application. The law says that a continuation application must be filed before the patenting of the earlier parent application, and that is found in 35 U.S.C. 120. Recently, the Federal Circuit decided on how before issuance should be interpreted. HTC was sued for infringing some of Immersion's patents on haptic feedback to users of electronic devices, and HTC argued that some of Immersion's patents were invalid over prior art, so the priority date of the patents was a contested issue since it determined the universe of prior art that could be applied. HTC argued that before meant that the continuation patent application must be filed at least one day before the parent application issues, and Immersion had filed a continuation application on the same day the parent issued, and this was specifically permissible and discussed as being appropriate in the Patent Office guidelines. In siding with Immersion, the Federal Circuit noted that the long history of Patent Office practice going back at least half a century reflects the PTO's procedural authority to define when the legal acts of filing and patenting will be deemed to occur. And in particular, the Federal Circuit referenced a 1968 PTO guideline that said that parent applications and continuation applications must be co-pending. The current version of the MPEP also uses the word co-pending, and it states that if the prior application issues as a patent, it is sufficient for the later filed application to be co-pending with it if the later filed application is filed on the same date or before the date that the patent issues on the prior application. The Federal Circuit also referenced a 1984 Supreme Court opinion of Godfrey versus Reens to support its holding, and it further stated and mentioned that investment-backed expectations and reliance interests in patent law are often strong and played a factor into the court's interpretation of the filing date and whether it was permissible for a continuation application to be considered as being filed before the patenting of a parent application if it was filed on the same day. I personally recommend that our clients make a decision whether or not to file a continuation patent application when the issue fee for the parent application is paid, or at least when you receive the notice from the Patent Office predicting the issuance date of the parent application. If you're time pressed, another safe procedure would be to file the continuation application at least a day before the parent issues, and this will ensure that continuation patent applications will remain valid even if the Supreme Court were ever to overrule the Federal Circuit's holding in this HTC case. If you have any questions about continuation patents or patent law, please contact me or any of the other attorneys at St. Onge, Steward, Johnston, and Reens. St. Onge focuses on obtaining and enforcing intellectual property rights in the United States, and we also work with foreign countries to ensure that our clients are adequately represented throughout the world. Thank you.